Cool. Sweet as. Alright, should we get started? Hey guys, I'm Jimmy. I did Torts last year. And does anyone know who this is? Jeffrey Palmer, who was involved in ACC. But anyway, this is the best slide I've got on the show. The rest of it's white background and Times New Roman. So, yeah. So what I'm going to go through today is general advice, some content that you guys hopefully have covered, and then the question that I had in the test last year. Actually, Nick's told me that the two streams have different content. Is that right? So Tobin's stream have done this stuff, right? And who's in the other stream? What have you guys done? What have you guys done? Yeah.
We've done that, and we've also done trespass to
Goods.
Person and goods.
Okay, and misfeasance and malicious prosecution as well?
No.
No, you haven't done that? Okay, so and you have done negligence?
Yes.
Okay, that's a bit annoying for you guys, but I'm happy to help you guys out with notes or whatever for the other stuff if it's not on this slide. So just let me know at the end. So yeah, general advice I have for torts is, first of all, like a disclaimer, is that this is kind of the way I study and the way I prepare for exams, and everyone's different, so if you have your own method and it works well for you, then follow that. And similarly, if Tobin or is it Maya tell you anything different about the exam, then trust them because they've written it, test driver. And these kind of last things are how I prepare. So a lot of people like tush notes or bond notes or that sort of thing. And personally, I actually prefer just using class notes. Like, so if you can go to class and take notes in class and not be on Facebook and make your own notes from those, I find that's way better because it's current, it's up to date. And what the lecturer says to you, they say with your test and exam in mind. So generally, especially with Tobin, we'll often like point out relevant cases. And if she points them out a number of times, she's probably going to put them in your test or exam. And yeah, so that's all I'd say is, if you haven't done it for this one, maybe you should think about that for the exam, like try and focus on class notes. And if you have time as well, make your own notes from those. Same principle really, I guess. And the final thing is do practice questions because torts is all about application. Like obviously you've got all the principles of law, but you need to kind of be able to apply it to the facts really quickly and succinctly, especially in the case of intentional torts, so practice is really good. The exception to that thing about it being really like fact-based is negligence, which is kind of like the most like public law contract type part of torts in the sense that it's really complex. It's like complex legal issues. So in that case, I found it was really useful to kind of just discuss with people and talk about the issues of negligence and application because often it can go either way. Yeah. And yeah, the other thing is I'm not really someone who uses templates when I prepare for exams. Some people will kind of make a template, go into the exam and basically write that out. And personally, I prefer having my notes and trying to be able to fit those into the question. And I think that kind of gives you the flexibility to be able to not mention parts of law which aren't relevant. So yeah, always plan your answers, even if it's like 5 minutes, just write down like 1, 2, 3, 4, the most relevant things. It just will save you a lot of time and stress partway through the test. Facts of the cases, especially in lots of tort stuff, unless the facts are kind of directly relevant to the facts you have in front of you, I wouldn't really recommend mentioning them because otherwise, especially like when you might be mentioning 5 cases in one particular area of negligence, for example, you don't want to have to go through the facts of each one. So really just like mention the kind of part of law which is relevant, and if you see like, hopefully like you'll know the cases well enough that if you see like an analogous fact situation, the buzzer will go off in your brain and you'll be able to write it down. But yeah, and the other thing about at the bottom there, it's always good to argue in the alternative, especially with negligence and stuff like defamation, which we'll do later in the year, because those are kind of areas in the law and torts where often it is unsettled, and you can go either way. And with that in mind, it's important to acknowledge that like it doesn't actually matter often how you decide. Like you need to come to a conclusion, but if you come to possibly the wrong conclusion, it doesn't necessarily matter as long as you've reasoned well, and you can have demonstrated you understand the law and how it works. And another note there, torts about protecting interests. I guess that's just something to keep in mind about like the reason like the law of torts exists is because it's private law which protects individuals' interests, and it's developed over years, over centuries, whenever the courts kind of see that there's an interest which might need to be protected by the law. And I guess like negligence is the most modern example of that, but everything we do is about that, so bear that in mind as well. I'm going to try and rattle through this stuff quite quickly because it's really kind of just statutory. Make sure with ACC especially that you just have all the important provisions. I've actually got some flowcharts in here which I'll show you guys in a sec, which I used. Doesn't matter if you don't have those ones, but make your own if you want. But flowcharts are just really useful because you can kind of work through the ACC stuff really quickly. And that's the best thing to do. You shouldn't get bogged down, like, did it happen in New Zealand? All that sort of crap. Like, that's never going to come up. You don't need to say that. Just say, like, was there a personal injury? What is meant by personal injury? What type was it? Was it physical, mental, work-related, or whatever? And then there's kind of specific provisions within that are relevant. And, yeah, vicarious liability especially, but also ACC, you might want some more in-depth notes as well as your flowcharts, just in case there's like a 10-mark essay question or something. Because obviously there's a bit of policy around vicarious liability especially. And yeah, just really trying to rip through these issues. Oh shit, didn't realise you can do a scroll. Yeah. So here's part of the flowchart I used, which hopefully you guys will be able to get from the slides later. So as you can see, it kind of just outlines the different type of injuries. Oh, that's actually after you've identified what type of injury, isn't it? But here we go, that's the one you want. So like, is it a personal injury? Yes. What type of personal injury? Or is it one's covered? Section 20 is an accident, work-related, that sort of thing. And as you'll see in the problem question in a second, often it'll be like a kind of really niggly, like, specific part of that. And if you kind of know it well enough, you should just be able to like scan through and go, okay, where is it? So I think it's like a prosthetic. It's a toupee in the problem question, and it's like, is it a denture or prosthesis? And I don't really know. It's up to you to decide whether it is or not. But yeah. So vicarious liability. I've got a lot of content notes here, so I'll go fairly quickly so we can do the problem question. So the rationale with vicarious liability is basically like, on the one hand, if someone's kind of like suffered a loss, then you want to be able to compensate them because that's, as I said before, what torts is all about. But on the other hand, maybe the person doesn't have enough money or is impecunious, so they can't pay for it. So in those cases, vicarious liability kind of acts to make that person be able to have compensation, basically. But at the same time, you're kind of trying to balance not imposing an undue burden on the business. So yeah, the elements sort of developed over a number of cases. The most important thing I think is that there's like that proximity of connection between the nature of employment and the tort committed. So that's in Heasley Hall, and then Catholic Child Welfare Society. The discussion about like whether it's part of the business activity, whether that creates an opportunity or risk for the tort to be committed, and that sort of stuff. So it's really sort of discussion on the facts within the parameters of those rules. Yeah, that's what I'd say about that. Limitations, really all you need to know, as long as you know each of those periods. Have you guys done limitations? You have, yeah. Or some of you have, maybe. It may not come up then, but if it does, literally all you're going to need to say is that, right? Something. Moving on to intentional torts, there's some general stuff, and I think this applies to most of them. Keep it simple, and when you start discussing them, always state the principle that's relevant, and then the interest that's protected. So, for example, battery predicts the inviolability of the human body. And if you say that every time, that's just like a tick for you straight away. That's probably 1 mark that you're going to get because you've recognised that. And then you can always come back to that later on when you're talking about damages as well. So yeah, state the principle, list the elements, and then kind of work through them individually, whether they're met or not, by applying the law to the facts, and move on. And you really shouldn't spend too much time on these, generally speaking, because I guess if some of you guys haven't done negligence yet, it might be a bigger issue in your test, and you might need to spend a bit more time. But what will probably happen is the problem question you guys get will be like, one massive question with like 5 different intentional torts, and you'll have to kind of identify each of them and work through them. So that won't be very fun, but and yeah, don't be too overwhelmed by them, because it's possible to have like a half-hour discussion on battery, I guess, but like they just would never want you to do that. They really want you to just say the crucial kind of principles and move on. So assault, as I said before, inviolability of the human body is the kind of principle it's protecting. That's when assault is any act which causes someone to apprehend the infliction of immediate unlawful force on his body. So this is an objective test, so it's about whether the person, like your action would objectively make a reasonable person apprehend harm. You have to have like present means to carry it out. Something Reed Coke is the one where the guy like goes across the table or something. And what else? It can be conditional as well. So that's police Greaves. And I think there's that really old case, Tubular and Savage as well, which talks about that. So yeah. Battery, same principle as assault. Actually, what a battery is an assault, except that you actually do it. So it's exactly the same. The important things there, I remember being really confused for a lot of last year about the hostile touching thing. It's not, so REF is kind of the authority for that now. It doesn't have to be a hostile touching, it's just any touching without lawful justification. So often what you're going to be discussing there is, I always kind of mention the implied consent exception. So the fact that, like, given that the least touching is enough, you commit like any number of batteries, within a day, except that there's this implied consent exception. So what you're really going to be discussing in most cases with battery, I think, is whether there's consent or not, or whether there's implied consent or not, and whether what is a battery kind of goes beyond what you might impliedly consent to. False imprisonment, a bit more complicated than the other two. The principle is really about freedom from physical restraint, coercion, and there's a Section 18 NZ Bora is something you might want to mention. It's like freedom of movement and stuff, liberty. You need a total deprivation, so it can't be like if you have an alternative way to get out, then it's not a total deprivation, so there's no false imprisonment. And then there are kind of 2 different categories within false imprisonment. There's a physical one, and then if it's a physical restraint, so that's like if you're locked in a room, for example, then you may be unaware of it, so that's in mirroring. And then the alternative scenario is when it's restraint is against one's will, and that's when I think you create the feeling of entrapment in their mind. So that's in persico. And obviously in that case, you have to be aware of it because it's in your mind. And in that case, it doesn't necessarily need to be like you physically are restrained, but you're under the impression that you are. And yeah, so it's strict liability, so you need intention to detain, but it doesn't matter. For example, if a cop thinks he has lawful right to detain you, but he actually doesn't, then he's committed false imprisonment. So you don't need an intention to falsely imprison someone. The other thing, if they're kind of harsh, they might like get into a police powers type debate in your question. Just make sure you have notes on that, and there are a couple of cases discussing it as well. Just like the police's powers to restrain you in certain circumstances and that sort of thing. And remedies. So I think you guys have all done remedies, right? Or damages? Yeah, cool. We actually did this like as our last topic last year, which really sucked because we were expected to talk about it all the way through the year, and no one really knew what they were. So you guys are lucky you've done it. Basically, if you're going to talk about ACC, if ACC is relevant, then you should talk about it at the end. So I always got tripped up by the fact that if there's like something which is a battery, I never knew whether to discuss the elements of battery, given that you would never actually take a case to court in battery in New Zealand. But I think generally they kind of want you to like show that you understand the elements of a battery anyway. So if there's a battery, it's like someone gets punched in the arm, for example, you'd go through the elements and say, yes, there's a battery, and then you might say, I think it's Section 317 of the Accident Compensation Act says that you can't bring a civil suit for personal injury in New Zealand. So you'd cite that and then say work through ACC, and then you might say Section 319 says you can get exemplary damages. If it was just a punch in the arm, it wouldn't meet the standard. But yeah, just another note on ACC. Generally, if you just see any kind of physical injury or any kind of any actually personal injury, then warning bells should be going off, and just note down like ACC and note to mention that at the end. The other important things about remedies, a lot of the intentional torts are actionable per se, which means you don't need proof of damage. So technically you could have a battery with no damage. So technically you could get nominal damages, I guess, for a battery if there was no personal injury. That's like really technical point. I don't think anyone would ever like bring a case about that. And that applies to assault and false imprisonment as well. Broadly, the types of damages you're going to get: nominal, compensatory, and exemplary. So nominal is really just acknowledging that a tort, like a wrong, has been committed against you. Compensatory is when there's been some sort of injury to you. And that compensatory damages tie back to the principles I was talking about before. So if you think about battery being inviolability of the human body, false imprisonment being the like restraint, freedom from restraint and stuff, and then later on in the year when you do defamation, like reputation and stuff. So compensatory damages are always tied to that and compensating for the loss of that. And then the final point is exemplary damages. And the important thing about them is that they're punitive, so they don't really fit within the schema of the rest of torts, in the sense the torts is about compensation and exemplary damages are punitive, so they're more akin to criminal law. So they really only happen when there's like a really extreme breach of someone's rights. So generally speaking, if you want to show off and know that you understand them, you might want to mention it, but generally speaking, they're probably not going to be met. Mm-hmm.
What's the authority for exemplary damages for intentional torts?
Crap, let me think about that. Couches kind of is the one for negligence, right?
Yeah.
I think there's Donslar is an early one. I think there are a few later ones. I can get back to if you want. I'll comment on the post when Nick shares these slides with the authority if you want, because I can't actually remember. Often with the authorities for this stuff, the best thing to do is just go through the cases for battery or for false imprisonment or whatever, and just read the judgment and see what they gave out. So for example, I can't think of one now, but if you look at a false imprisonment case, they might say the quantum of damages is X for compensating for this. And then, for example, I think Meering has a good discussion about the type of stuff in false imprisonment you might get damages for. The final thing is contributory negligence. Just note like whether that might detract from the amount of damages you get. Yeah. So negligence, I'm sorry if you're in stream 2 and this isn't relevant. So generally with negligence questions, there's going to be one area of negligence broadly within the duty, breach and causation sections that's really relevant to the question, because it's really unfair to expect you to discuss in detail each of those elements. So if you can, and I didn't do this in the test last year, try and identify which of those is most relevant. And if you don't, if you manage to kind of do an in-depth discussion of all of them, you're not going to be marked down for it. It's just that you're wasting time. Negligence is much harder to pin a particular principle on than the other torts. But if you were to, I guess look at Donahue and Stevenson, but it's sort of like taking reasonable care not to inflict any damage which is reasonably foreseeable. So it's sort of like a general duty to people. And that second point about negligence being about policy sort of ties into that. Effectively, what the law of negligence is restricting the extent to which you owe duties to people. So as you kind of read more negligence cases, you'll see that the judges are always really careful not to impose indeterminate liability. This idea of a duty being owed to the world, and a slippery slope. So as soon as they allow negligence in one particular case, suddenly there's going to be a flood of cases on that, and then basically everyone's going to be litigated for minor actions. So although there are kind of specific parts of negligence which deal with policy, in reality sort of all of negligence law is to varying extents trying to limit the extent to which you're liable. So the first thing about duty is, this ties back to what I was saying before. If you see the fact scenario and it's really similar to a case you've done, then straight away you should know that duty's probably not going to be the important part of the question. So you can basically use reason by analogy. And then the South Pacific test, which is confirmed in North Shore City Council, is really only for novel fact situations. If the duty is the important part of the question, then they'll want you to kind of really go through this in detail. And this is only like a skeleton. This isn't everything you'd want to consider. The overall question is whether it's fair, just, and reasonable to impose a duty. And then it's a 2-stage test, but it's kind of technically a 3-stage test, because the first stage is internal relationship, but that considers foreseeability as like a screening test, and then proximity. So foreseeability is kind of involved in every stage in negligence, which is kind of annoying, but yeah, just deal with it kind of quite briefly here, I guess. And you can kind of deal with it with proximity, because they're sort of related. So proximity is like the internal relation, so everything about your relationship in your particular, I guess, like on the facts with the person who you've potentially harmed by your negligence or the damage you've caused. So you can kind of pick up more on that from the cases, but it's sort of just about like stuff like locality, like where you are, how dangerous the particular activity you're engaged in is, and that sort of stuff. And sometimes it's easy to overthink it. Like often it's actually quite obvious when you think about it. Like I think in the problem question we've got later, there are people playing with fireworks on the side of a road. It's like, I remember when I was in the test, I was like, oh Christ, like is there a duty? It's like, actually, obviously there's a duty because they're playing with fireworks, right? Like on the side of a road, there's obviously like a massive risk. So you shouldn't, like, don't get too caught up on that. If it's kind of there, it's there. If it's not, it's not. But it will be there because otherwise the test ends. So yeah, actually that's probably the crucial point, is that there's always going to be an arguable prima facie duty. Then the second part of the test is about external issues, so policy. And South Pacific's probably the best case for this. It's got a massive list. I think Lord Cook has like 10 points which he says are relevant to establishing a duty. Policy factors to consider whether a prima facie duty should be upheld or not. And as you kind of go deeper into negligence with like mental injury and relational economic loss and all that shit, you'll see a hell of a lot more of this. But some of the general ones to keep in mind: indeterminacy, so that's like how identifiable the particular class of person who you might owe duty to is. Stuff like floodgates, reliance, and also the type of loss. So like if it's an economic loss, I think generally it's not included. And this is something Tobin always reminds us as well, like this is a broad framework, not a straitjacket, so you don't need to follow this strictly. It's probably easier to, but yeah. Breach, Wagon Mound is sort of the authority for breach. So the standard is what a reasonable man would do in the circumstances, considering likelihood of risk, the gravity of the risk, social value of the activity, how burdensome it would be to alleviate the risk, and also like external standards. So that's like if, I guess like solicitors is one example, like the solicitors have like private kind of standards of ethics and stuff, so if those are relevant. And sort of similar to like negligence, like over broadly negligence, generally only a few of these are going to be relevant. So you might, like for example, social value might not be relevant, or you could just say there's no social value. Or it might be like a thing you want to discuss really in depth, and it could be like the crux of establishing whether there's a breach. So yeah, kind of deal with each of these in turn. I kind of use this as a checklist, this stuff, like how likely is it that a risk is going to eventuate, and you can kind of discuss like on the facts. So Bolton and Stone is that classic example. This is a cricket case where they're playing cricket and they hit a car, or they hit a woman actually, I think, who's on the street outside, and I get what I think it's Lord Reed maybe says there is that the standard for likelihood is that if there's a real risk, even if it's really small. So that's the sort of thing to discuss, is that if this thing's happened once in 200 years, and it's like a complete freak accident, maybe it's not really a real risk. But I think in that case it had happened maybe 5 times over the past 20 years. So at that point they're like, yeah, there's a real risk, no matter how small it is, that someone's going to be injured. So at that point there's kind of enough likelihood. Gravity of the risk is all about like the consequences. Like, so for example, and then these sort of like, you kind of balance all of these. Like some will argue for a breach and some will argue against. And I guess what you're really doing is like weighing it all up. Like overall, where does it lie? Like where does the balance lie? Is it in a breach or not? So for example, it could be like a really small likelihood of it happening, but the gravity of it, if it did happen, is really serious, in which case, you know, you're more likely to say there has been a breach. Social value of the activity tends to argue against a breach, so that's like the cricket thing, you know, you could argue cricket is like, there's a lot of social value in playing cricket, so although there's like some risk attached to playing cricket, we don't mind, there's no breach here because we want to encourage people to keep playing cricket. And how burdensome alleviating the risk would be is like, just if it's kind of self-explanatory, right? Like, if it's easy to like closing a cricket club or closing a cricket ground, for example, like the Basin Reserve in Wellington is a cricket ground in the middle of like a massive, there's a massive road that goes right around it, including the state highway. So if you were to, like, there's a risk, but also it's a major cricket ground, so maybe you could say it would be really burdensome to close that because it's like a 100-year-old ground and people have been playing there for years. So that's where you might make the argument. Yeah. Causation, remoteness. There are sort of 2 crucial things to this. Cause and fact and cause and law. So that's, like, as soon as you move on to the section, always kind of state that. And the overall principle is that the damage has to be causally linked to the breach of the duty. So you might be in breach of your duty, but that breach actually has to result in the damage that's been suffered. And Ambrose is one authority for that, but there are lots. So cause and fact is kind of just like a factual determination, and then cause and law is more of a thing, is more the remoteness part, and that's more a policy question of whether the law is willing to impose liability on this person for what they've done. And it's about proximity between the cause and the damage. So cause and fact is the but-for test. Hodson's one authority for that, but there are lots. So that's, I think there are lots of medical cases which are relevant to that, and often what they talk about is like more than 50% chance. So that's like a very factual determination of whether, like, did this cause it, yes, no. That's usually not sort of too important. The only other thing to note is when there are multiple causes, and then Fairchild is the authority for that, and that's where, so for example, if I think it's asbestos poisoning, so this guy's worked in like a number of places over his life where he's got asbestos poisoning, and they can't prove that he got the cancer from any particular one of those places, but what he can prove is that like it's very likely that he could have got it from any one of those places. So what they find is that all you need to prove is that it materially contributed to your injury. And I guess like you can see the policy behind that, which is just like not allowing someone who's been injured to go without compensation for that loss. And important to note as well with the multiple causes thing, that's not relevant to ACC. So some of like the pregnancy cases and stuff, you can't talk about multiple causes. You may not have done Ambrose yet, but that's what they say in Ambrose. That's just like, that's a really niche thing which might come up where like negligence within the medical fraternity, but I don't think it'll come up. And cause and law is all about remoteness. So the question here is whether the kind of damage was foreseeable. So the law which is in Hughes and Lord Advocate is the extent to which, let me rephrase that, is, oh Christ, just been really looking at the screen for too long. You can actually just read it, I didn't take it. I'm just like looking at these slides, I just can't even read anymore. So to rephrase, the extent to which the damage is caused is irrelevant. but what is relevant is that the type of damage which was foreseeable is the type of damage which is caused. So it doesn't matter if only like a small, for example, in the case of a burn, like only a small burn was foreseeable. If in the circumstances like there was a terrible fire and the person was burnt to death or something, or like the whole house was burnt down, that's like still the kind of same class of injury, so that falls within it, and it's irrelevant that the extent was much worse. And the final thing, which is in geothermal, Tobin loves this case, is that it's important to, she probably mentions this like all the time if you're in a class, is I think it's called the eggshells principle, so you take your victims as you find them. So like that's the impecuniosity thing, so like if your victim, I think in that case they couldn't afford to fix their business after the initial negligence, so they suffered more loss as a result. And that's a case of where you take your victim as you find them, so they still had to compensate for all of that loss, even though if the victim had maybe had more money, not such a great loss would have resulted. So yeah. Some final stuff. That's the thing I was saying before about Ambrose. Fairchild doesn't apply to personal injury in New Zealand, but don't worry too much about that. Thing about damages compensate for all reasonably foreseeable harm. So that's in Bernie and geothermal. Bernie's actually a really good case. I don't think it's in the casebook. It wasn't last year. But this is really sad that I did this, but I actually went on like LexisNexis and found the case and downloaded it and read it, and it was really worthwhile. It's really useful. So I'd recommend doing it. Because it's got a really good discussion about like the kind of loss which is foreseeable. Yeah. As Steve mentioned before, exemplary damages are available in extreme cases of negligence, and that's in Couch. But chances are they won't come up. I mean, that's like really, really extreme, because when you think about negligence, like by its very definition, it's not tied to intention, and by like the definition of exemplary damages, they are tied to some sort of like intention, because it has to be something really serious that deserves punitive punishment. So it's really unlikely to come up. But if there's like very extreme negligence, you could maybe argue it. The other thing, have you guys done intervening causes and res ipsa loquitur yet? You may not have. You have? It's going to be in the test? Okay, shit. Well, it is, yeah. Okay, so the intervening cause stuff it's sort of related to the crim stuff. It's just about causation. And it kind of arises in situations where, like the classic case of the squatters cases, so where there's been like some initial negligence and then squatters intervene and like make the damage way worse. And the question is whether the person who caused the initial breach is damaged for all that resulting damage. And similar to everything else, like we've just done with causation and remoteness, the question is really whether you can kind of tie that resulting damage to the initial breach. And then Lord Reid and Dorset Yacht kind of says that there's a different the test isn't just whether it's reasonably foreseeable, the test is whether it's very likely to happen. And then there's kind of this later law in Lamb and Water especially where they say it's actually just, is the action of the third party a reasonably foreseeable consequence? So I think probably follow Lamb and Water because it's the more recent law, but maybe mention Dorset Yacht. Res ipsa loquitur, really throwaway point I think. In a negligence question, really all it's about is in cases where, like the classic one is a car accident. So if you're driving along the road and there's like a car crash, chances are someone's been a negligent driver. You might not be able to prove exactly what happened, but often the thing about res ipsa loquitur means you don't have to prove exactly what happened, so the evidentiary burden just shifts to the defendant. So you kind of raise the presumption of negligence. So say like there was this crash, I was just driving along the road and then I got hit by the car. So like, I don't know, like I stayed in my lane, for example, so the only reason there could have been an accident is if they were negligent in some way. And then the burden would shift to the defendant to prove, or to disprove negligence. So here is my negligence problem question from last year. Has everyone done it? Some of you may not have, right, who haven't done negligence. Does anyone need a few minutes to read it, or do you guys want to jump straight into it? I'll give you guys like 2 minutes. I need a break anyway, so.
Have you I think the question 2 is on?
Yeah, I removed it.
Oh, cool.
Yeah, cool. Fuck, man. It's hard being a lecturer. I
Yeah.
a real phrase to
Hey,
learn. It's
nice
like,
reading, man. You're doing well.
I was just like,
I think everyone has like started negligence.
okay, cool.
Yeah.
Yeah. What's up, bro? Yep. What's that, bro? Huh? Yeah, you're on there. Yeah. No worries, bro. Alright, are you guys all done? Cool. I tell you what, I really need that break. I've spent like all day doing 399 in the day, and it's just frying my brains out. So, thanks for allowing me that. So, these are sort of the areas of law that I thought were relevant in the question. Negligence is obviously like 80 to 90% of the question, and then ACC is relevant at the end. And you can kind of approach, like with any problem question, you can approach it by claimants or by torts. And I think it's sort of best to determine what approach is best when you read the question, because with some questions, you know, like it's just easier to, like, for example, each claimant has issues are just different, and like there's only one tort relevant to each person. But if like torts cover more than one person, generally I think it's better to deal with it by tort. And I thought you could probably do both here because it sort of just works that way. Also, don't fall into the trap. When I did this in the test, I mentioned battery at the end as a really throwaway thing. The stupid thing about that is that it's clearly there's no like intention, right? So battery's not met. So negligence, I didn't really think duty or breach were the relevant things here. So this was kind of my discussion I had. Like, if you're talking about like the proximate, like the first stage of the test, the internal relationship, you can probably say like, yeah, it's reasonably foreseeable. They're close to the road. They're doing a really dangerous activity, like playing around with fireworks. It's pretty obviously like something, you know, the kind of act which would cause you to owe a duty to a class of people around you. So you could talk about like maybe the class of persons who they might owe a duty to would be like road users, pedestrians, that sort of thing. And in terms of policy, like, I mean, I can't think of, like, if you guys thought of anything, good for you, but like, I can't think of any reasons why you'd want to encourage like people to be playing with fireworks on the side of the road. And in fact, like, arguing the other way, you could probably say like there are like lots of policy reasons why you would want to discourage this. So I think it's pretty easy to say, yeah, there's a prima facie duty, and yes, like, policy reasons support the imposition of that duty on these people. So, I mean, like, it's good to show that you know the law when you've got this kind of question. Like, even if you know the duty's not that relevant, like, mention South Pacific, mention North Shore City Council, and if there are any particularly relevant, like, policy things, mention those. But, you know, like, the reality is that you probably don't want to get caught up discussing it for too long. And in terms of breach, if you go through the Wagon Mound 2 test, then you can say, like, I mean, you might want to say, like, I need more facts to know exactly, like, was it a major road or not? Like, how close were they actually to the road? Like, what time of day was it or whatever? But you can probably say, like, look, it's pretty obvious that if you're letting off fireworks next to a road... Do you have a question, Rich? Yeah, sorry, yeah.
Would you want to talk about, like, the low chance of it going up the exhaust pipe?
Yeah, true. You could talk about that. You could also talk about that in, like, remoteness, I guess.
Right.
But, like, because that... I mean, yeah, I think what you'd actually do is you'd talk about that in remoteness.
Right.
And what you'd say is... Because that's a classic example, right, where the damage didn't occur in a foreseeable way, but the type of damage which resulted is the type of damage which was foreseeable. So if you're like playing with fireworks, you expect the damage that results to be fire damage. You might the most foreseeable thing might be that it just hits someone in the arm or something, right? Or just hits the side of a car and like burns some paint off. But even though it occurred in a really unusual way, so this is similar to Hughes and Law Advocate, like going up an exhaust, that's very unlikely to happen. The fact of the matter is it's the same type of damage which was foreseeable, so that means that it is kind of met, but I'll talk about that later. So yeah, in terms of breach, like you can say there was a real risk of something going wrong, and obviously like potential for grave consequences, and we saw those because there was a massive car fire and someone got really badly burnt. And then social value, like obviously there's not much social value attached to playing with fireworks, so yeah.
Just a question about those two stages. Did you actually talk about them generally, or did you break it down briefly to each of the, like, E, F, G, H, or did you think they applied in the same way, so you were just going to talk about them generally?
Yeah, sure. I mean, I think so there's E, F, G, H, right? And E, F are negligence, and then G, H are kind of two passers-by, right? I think at this stage you can probably talk about it as one thing. So, for example, like when you're talking about with the owe duty, all of these people you can kind of presume are people who are the pedestrians or road users, right? So they're kind of like within the class of persons which they might owe duty to. And then similarly in terms of breach, that sort of applies. I think I think you kind of I think it's best to start distinguishing later when you're talking about causation and remoteness. But that's just my approach. Sometimes you can. There are different approaches, and it doesn't really matter. Like as long as you kind of show that you understand the law, they won't mark you down if you do it slightly differently. So yeah, as I kind of said, I thought this was like the crux of the issue. So the most important thing here I thought was the cause and fact, and the multiple causes. So that's like straight away when you see like, because they make it very clear. I think they mention like a number of times that there are multiple fireworks that go off, and then it's impossible to know whose firework went up the exhaust, whose firework hit the person, and that sort of thing. So it's quite obvious that they want you to talk about multiple causes. And then you could have quite a good discussion probably if you wanted to about McGee and Fairchild, and you talk about how you don't actually, all you need to show is that the breach materially contributed to the damage. And also there's that policy discussion in Fairchild. You could talk about like the unwillingness to leave like a worthy plaintiff without a remedy. And that's sort of the policy behind multiple causes law, which is like basically a lower standard of proof than the rest of negligence. And then if you wanted to reason alternatively, you could say actually like these are really exceptional cases, and then the law doesn't really want to have to lower the standard required like easily, so maybe it's not met, but I think you could probably say it is. I just realised I should have said this earlier. This is another really important thing with negligence is even if you think like a duty is not established or there's no breach of the duty, you should still work through it all as if there was, because yeah, just good like to show you know all the law and stuff. Yeah, and then in terms of cause of law, this goes back to what I was saying before. So I think what they'd want you to talk about here is that the damage that was caused is of like the class or kind that is foreseeable, and the extent of the damage is irrelevant, and the particular way it happened is irrelevant as well. So in Hughes, I think it's the case where there's like roadworks going on, right, and there's a kerosene lamp, I think, and there are the kids playing, and I think one of them falls in or something, and there's a massive explosion. He's really badly burnt, and that was like a really freak accident. But what the judges said in that case was that if you've like left this kind of kerosene lamp unattended, the type of damage which is likely to happen is like a fire damage, even if it's just like a minor burn. So the fact that they fell into like the well and it exploded up and burned the kid really badly doesn't matter because it's the type of damage which is relevant, and the severity is also irrelevant. This is where I started in my question dividing up between the different plaintiffs. So you'd say there's fire damage to E, to F, and also you could say to G and H. And then you say it's foreseeable. I think that's probably met because of each of I kind of like to deal with like the class thing, the extent, and just show that you know that law and then apply it individually. So yeah, that's it. And then there were a few kind of further discussion points on that. another point of discussion might be that F is an intervening party. So F, like, wasn't actually hit by the firework. F intervened in order to save, well, they thought E was in the car, so they intervened to save them. So there you might want to discuss, like, to what extent is A to D liable for the actions of this, like, freely acting person. So you could, if you wanted to say they're not liable, you'd say, look, F acted completely of their own volition. They ran into this, like, immensely dangerous situation and they harmed themselves, but, you know, they're an adult. That's their problem. The alternative you could say is that there's, like, a clear nexus between the negligent act and the breach and what resulted. So, like, it's obviously, like, I'd argue that it's reasonably foreseeable that if you let off a firework on the side of a road and you hit a car and there's a bit of fire, that other bystanders are going to try and help that person, because that's, like, kind of, I guess, what you'd expect of reasonable people, like good people. So I think you could argue either way there, and as long as you kind of show that you understand what the law is, what the law requires, and whether you think it's met or not, and kind of apply that to the facts, you're going to get marks. Another thing, I'll mention the wallet thing quickly before damages. You could also maybe say, like, there's $3,000 in the wallet. Like, is it really foreseeable that someone's going to be carrying around $3,000? Is that, like, or is that kind of too disconnected? And should you have to compensate for that? And that's related to the issue of damages. Like, you only compensate for all reasonably foreseeable harm. So, is it reasonably foreseeable that people carry around $3,000 in their wallet? Like, I mean, no, not really, but at the same time, like, it's reasonably foreseeable that people carry around, like, money in their wallet, right? And that people, like, there's value attached to people, like their clothes or whatever. So, I reckon you could, like, say that it is foreseeable. Otherwise, you could say no, it's not. It's heaps of money. Once again, as long as you show that you know the law, it doesn't actually matter what you say. And as soon as you've kind of worked through all of that law application, what you want to say is, well, there's a car that's been damaged, there's, like, a wallet, and those are, like, property, so those can be covered. You can bring a civil suit to get compensation for those. However, there's also personal injury in the case of F, and then also in the cases of G and H, so those wouldn't be covered. So then you're going to jump to ACC. And then this is what I was saying before, like, when I did this question last year, I spent probably, like, we actually had another 10-mark question at the end, but I spent, like, by far the majority of this question talking about the negligence and working through all the facts and applying the law and stating the law, because as you can kind of see, there's, like, a lot of law to state with negligence, and that's just always the case because you're working through all these different stages. So when you get to the issue of ACC, you really want to just rattle through it. You don't want to have to, like, spend 20 minutes working through it. So just say, yeah, look, there was a personal injury, it was a physical injury, it was an accident, and actually under section 25, which is the accident section, is actually a specific thing for burns. So that's the kind of thing they're looking for, is that you know how the ACC framework works and that you can look through it and identify that the particular facts that have happened are covered in this particular provision. That won't always be the case, but when it is, like, that's, like, probably a mark or two just from noticing section 25(1)(c). So there's cover there. G, exactly the same, right? H, so with G you could deal with F and G together under ACC. And then in terms of H, the discussion is just section 26(1)(e), which is prosthesis and dentures. So you just want to talk about whether a toupee is considered like a prosthesis or dentures. I mean, and another part of that provision is that it says it replaces part of a human body, like hair is part of a human body, so, and it's like akin to like dentures, I guess. So, yeah, I think what did I say? I actually said probably not on the slides, but on it probably is actually covered. Honestly, like, it doesn't really matter as long as you discuss. And I'm done. So, any questions? Nope. All good. Sweet. Thanks, guys. Good luck. No worries.
Short one.
No worries. Was that helpful?
Yeah, that's good.
There are actually provisions on that. I think there are some exceptions to that. So I looked for my notes.
Exceptions as in you won't be covered, or you
I think
will.
sometimes you aren't covered.
But most of the time you are.
Most time you are, because like the idea is that it's like a no-fault scheme. So like basically there's cover for every kind of I'll look it up, but we're just like looking like just looking at it, just like get it off on the website and like find
Would you work through all the sections for each of the individual plaintiffs? Or would you
for ACZ, no as well.
up for the negligence?
I think you're probably kind of like wasting your time if you do that, because as you can see there's like a lot of law doctrine always.
Yeah.
So I think the best thing to do would be